vous asseoir. L'audience est ouverte. La Cour s'est réunie aujourd'hui pour entendre le second tour des plaidoiries du Royaume du Cambodge. Je donne à présent la parole à M. Rodman Bandi pour ouvrir ce tour des plaidoiries. Vous avez la parole, monsieur.
Thank you very much, Mr. President. Mr. President, members of the Court, in leading off Cambodia's second-round presentation, I will address two issues that continue to divide the parties. The first concerns Thailand's assertion that there's no dispute between the parties over the judgment's interpretation, because for 40 years Cambodia recognized and accepted Thailand's interpretation based on the red line appearing in the 1962 Thai Council of Ministers map and the barbed wire fence. This was a line of argument that was advanced by Professor Pillay yesterday morning, and I shall show that it's unfounded. The second issue I'll address concerns the arguments presented by Madame Miron about maps, specifically Council's contention that the maps presented in the original case support the position that the vicinity of the temple should be limited to a very narrow strip of land flanking the temple. And I will explain why that contention is misconceived as well. And with that introduction, Mr. President, let me turn directly to the question of the existence of a dispute over the interpretation of the judgment. In my presentation on Monday, I took the Court through a large quantity of evidence showing that following the Court's judgment, Cambodia repeatedly took issue with Thailand's interpretation of the judgment and its construction of a barbed wire fence hemming in the temple along the red line adopted by the Thai Council of Ministers. And Cambodia, in those protests, viewed Thailand's line as fundamentally incompatible with the map, with what the Court had decided in 1962 with regard to the frontier delimited by the Annex I map. Yesterday, Professor Pillay tried to nibble away at the weight of the evidence by selecting isolated incidents taken out of context in order to support the assertion that Cambodia has always agreed with Thailand's interpretation of the judgment. Now, that line of attack cannot be squared with the factual record. I start at the beginning. The origin of the dispute lay in the Council of Ministers' decision in July 1962 to limit the vicinity of the temple along the red line, which was the second of two proposals that Thailand's experts put forward. Professor Pillay had no desire to speak about the first proposal, the yellow line, and that's a matter that my colleague Sir Franklin will come back to later. Instead, Professor Pillay made 2 points about the red line. First, he said that in no way was there a question of the line marking the frontier between the two countries. And second, he drew attention to what he felt was the quasi-coincidence between Thailand's red line and the watershed line said to have been pleaded by Cambodia in the original proceedings. Now, as for Professor Pillay's first point, the red line was not a boundary. It's contradicted by what Thailand itself said later. Now, the map on the screen is an enlargement of Thailand's secret map L7017, and it was labeled secret on the map, provided to Cambodia in 2007, and you've seen it before. It was in tab 13 of our original folders. In the temple area, as you can see, it shows a line that follows the Council of Ministers' red line. Now, what did Thailand say about this line? Was it a boundary? Or was it merely an estimate of the temple's vicinity? And the answer lies in an aide-memoire prepared by the Thai Foreign Ministry dated 17 May 2007, which addressed Cambodia's UNESCO application regarding the inscription of the temple. And the relevant passage from that aide-memoire reads as follows, and you can see it on the screen. This is the Thai Ministry of Foreign Affairs speaking. In this regard, the Royal Thai government firmly states that the above-mentioned Cambodian documents cannot in any way prejudice the existing international boundary between Thailand and Cambodia as appeared in the map scale 1 to 50,000 series L7017, which was Annex 6 to the aide-memoire. So contrary to Council's contention, it is clear that Thailand does, in fact, view its red line as an international boundary. But it's a boundary that cannot possibly be reconciled with the court's judgment, given that the court found that it was the Annex 1 map line that had been accepted by Thailand as the frontier line. Now, as for Professor Pillai's second point, that Thailand's 1962 line largely coincides with the watershed line pleaded by Cambodia in the original case, this too is misleading. It's perfectly clear that Cambodia's position in the original proceedings was that the Annex 1 map line constituted the boundary between the parties in the region of the temple. The court said as much at page 21 of its judgment. The watershed line that Professor Pillai was referring to was not Cambodia's claim. It was simply a demonstration by Cambodia's experts at the time to rebut, on a technical level, the course of the watershed that had been advanced by Thailand's experts. And as I pointed out on Monday, neither watershed line was considered by the court because they were not relevant in the light of the court's pronouncement about the status of the Annex 1 map line. Now, Thailand now wants the court to believe that Cambodia agreed with Thailand's interpretation, the red line interpretation, because it lay close to Cambodia's own watershed line. And indeed, yesterday, Thailand's agent said that the only line that Cambodia pleaded in the original case was the watershed line appearing at Annex 66 of its reply in the original case. With respect, that's incorrect. When Cambodia, as I said in the original case, pleaded the Annex 1 map line, and the court recognized that at page 21 of its judgment. And when Cambodia repeatedly protested Thailand's red line and its barbed wire fence throughout the 1960s, that was because the red line bore no relation to the frontier between the parties depicted on the Annex 1 map, not because it was inconsistent with any watershed line. Professor Pillai then referred to a speech that Cambodia's foreign minister made on the 27th of September 1962 before the United Nations General Assembly. Counsel argued that the foreign minister acknowledged that Thailand had complied with the judgment. But my good friend only cited part of the relevant passage from the speech. What counsel neglected to mention is that right after the part that he quoted, Cambodia's foreign minister went on to say the following, and I quote, "Thailand could have done so, could have complied with the judgment in such a way that friendly relations would have been reestablished between our two nations, which Cambodia, for its part, greatly desired. Unfortunately, the deception practiced by Thailand was demonstrated by its occupation for several days of a strip of our territory in the neighborhood of the temple." The occupation. And regrettably, that occupation did not just last for a few days. It persisted throughout the 1960s, and it was backed up by the barbed wire fence and Thai armed forces. And that is what led Cambodia repeatedly to protest the fence and Thailand's failure to withdraw to the frontier line depicted on the Annex 1 map. Now, my opponent next took aim at Prince Sihanouk's visit to the temple in January 1963. Counsel referred to a United States Embassy dispatch which recorded that when the prince referred to the barbed wire fence, he only described it as encroaching on Cambodian territory by several meters, and that he would not make an issue of the matter as these few meters were unimportant. What counsel failed to take into account was the context in which the prince's visit took place. 4 months earlier, in August 1962, Prince Sihanouk was already on record as complaining vigorously about the barbed wire fence. In November 1962, Mr. Gussing, whom the court may recall was the Secretary General's representative to mediate between the two parties, he expressed concern that the prince's visit to the temple might spark a border incident. Mr. Gussing, in his report, indicated that his mission, however, had been given to understand by the Thai authorities that their soldiers, the Thai soldiers, would not interfere with the visit as long as the prince and his entourage remained strictly within what Thailand considered to be Cambodia's territory, Cambodian territory marked out by the barbed wire fence. Of course, any notion that Cambodia's territory was limited under the 1962 judgment to the barbed wire fence is spurious. Nonetheless, the clear implication was that there would be trouble if the prince tried to pass beyond it. Now, the official retaking of the temple by Prince Sihanouk in January 1963 was a momentous occasion in Cambodia. The temple had been illegally occupied by Thai armed forces since 1954, and there was no desire to provoke an incident on such an important day, and the international community breathed a sigh of relief when the visit went off without incident. And that was why the prince was restrained about the barbed wire fence while he was at the site. But that being said, I should point out that there's another account apart from the U.S. Embassy account. There's another account of the prince's visit, which may be found in Annex 6 to Cambodia's response, and that account is a contemporaneous report of the prince's remarks to the Cambodian press when he traveled to the temple. After observing that the occasion was an historic one in Cambodia, the prince noted that while Thailand had evacuated the temple itself, it had traced a new boundary in the vicinity of the temple with barbed wire and installed military posts that encroached on Cambodian territory in defiance of the court's judgment. Now, that scarcely suggests that Cambodia's head of state accepted Thailand's unilateral interpretation of the judgment. Professor Pillay then tried to draw a parallel between Prince Sihanouk's visit to the temple in 1963 and Prince Damrong's visit to the temple in 1930. But the attempt was entirely artificial because there was a world of difference between the two situations. Unlike Prince Damrong, Prince Sihanouk protested Thailand's barbed wire fence before he visited the temple, when he visited the temple, and a number of times afterwards. And Prince Damrong, in contrast, remained silent. To recall the facts that are on the record, Prince Sihanouk repeated his complaint that Thailand was refusing to recognize the frontier referred to in the court's judgment in January 1965, November 1966, October 1967, and February 1968. And that's in addition to all the other protests emanating from senior Cambodian government officials to the same effect, a number of which I canvassed on Monday. And I invite the court once again at its leisure to look at the record of Cambodia's protests that we summarized in tab 10 of Monday's folder. When a state objects as many times as Cambodia did, it is not over a few meters. Moreover, Cambodia's complaints included references to the fact that the barbed wire fence was incompatible with the Annex I map line. And you can see that if you refer to the third and fourth entries on the list in our tab 10. In the light of the totality of the record throughout the 1960s, it cannot credibly be maintained that Cambodia shared Thailand's understanding of the judgment or that there was no dispute between the parties. Both of the United Nations special representatives, Mr. Gussing and Mr. de Ribbing, knew there was such a dispute. Diplomatic missions knew it, the press knew it, and Thailand knew it, and the documents speak for themselves. Now that takes care of the first 10 years of Professor Pillai's 40 years of Cambodian acceptance of the Thailand's line. There was no acceptance. With the exception of a brief period from 1991 to 1993, when the United Nations Transitional Authority was installed in Cambodia, the next 28 years after 1969 were a period when the temple was off limits due to the presence of the Khmer Rouge in the area. That's from 1970 really to about 1997. And even when the temple was temporarily open to tourists early on in the 1990s for 1 or 2 years, Thailand made no mention at that time of its Council of Ministers line. And clearly there was no acceptance by Cambodia of Thailand's line during this period either. As I pointed out on Monday, by the late 1990s, Cambodians were able to resettle in the temple area. The pagoda was built in 1998, market established, and hundreds of Cambodians lived in the area, and there was no protest from Thailand in 1988, 98, 99, or 2000, and no mention, certainly, of the Council of Ministers' Red Line. In 2001, Thailand did begin to raise concerns about pollution in the temple area. But once again, there was no mention that Cambodia's activities were contrary to Thailand's interpretation of the court's judgment as set out in the Council of Ministers resolution. Professor Pillai implied that Thailand closed access to the temple at that time in 2001 because Cambodia's activities were taking place in Thai territory. But Thailand's own documents show this to be untrue. And if the court refers to Annexes 27 to 29 of Thailand's further written explanations, they explain that the entrance to the temple was closed because of Thai complaints about pollution, not because Thailand was somehow pressing its red line map. The dispute only resurfaced in 2007 when Thailand produced a copy of its L717 map with an aide-memoire claiming, as I mentioned earlier in my remarks, that the map showed the international boundary between the two countries. In July 2008, Cambodia protested Thailand's new map, noting that it was contrary to the Annex I map relied on by the court in its judgment. And for its part, Thailand protested Cambodia's reliance on the Annex I map as determining or as delimiting the frontier in the area of the temple. So the dispute over the judgment's interpretation had clearly re-emerged at that time. Now, Thailand argues that the dispute came to life because of a map Cambodia prepared in connection with its submission to UNESCO to have the temple inscribed as a World Heritage Site. Cambodia considers, on the other hand, that the dispute resurfaced because of the new Thai map. But it makes little difference which party is right. What is clear is that there was a dispute over the meaning and scope of the judgments. And that is what is required for the admissibility for a request for interpretation, and it's a condition that Cambodia has fully satisfied. Mr. President, I now turn to the second part of my presentation, in which I will address the use to which Thailand tries to put various maps in order to limit the vicinity of the temple under which it is an obligation and from which it has an obligation to withdraw. Now, to accomplish this purpose, Council focused on the map that now appears on the screen. It's a reproduction of a small part of what has been called at times the Big Map contained in Annex 85D of Thailand's pleadings in the original case. Madame Millon contended that this map is a veritable cartographic representation of the geographic extent of the original dispute. And Council then went on to claim that this partial reproduction of the Big Map can be considered to illustrate the area of the temple as the court understood it in 1962. Madame Millon's first argument in support of that contention was textual. She maintained that the following passage that I'll read, taken from page 15 of the court's judgment, supported Thailand's restricted view of the temple area. Now, that passage she cited was the following, and I quote, "A frontier line which ran along the edge of the escarpment, or which at any rate ran to the south and east of the temple area, would leave this area in Thailand, whereas a line running to the north or to the north and west would place it in Cambodia." Now, I fail to see how this passage assists Council's argument. The court made no reference to the Annex 85D map as limiting the disputed area in what it said in the passage I just quoted. In fact, Mr. President, the Annex 85D map, whether the Big Map or this extract, is never mentioned in the judgment. And how Thailand can claim that the small portion of the Annex 85D map is what the court had in mind as the area of the temple is a mystery. The passage in the court's judgment also refers to lines running south and east, north and northwest of the temple area, not simply the temple. The temple area was not defined nor confined by the court in this passage. And it's simply a non sequitur to argue that the area of the temple referred to at page 15 of the judgment must be Thailand's claimed area because of a map that is not once referred to in the judgment and that contained watershed lines that the court never even considered. Now, as I said, the Annex 85D map covered actually a much larger area than the small portion displayed by Madame Millon. But in fairness, I should point out that Council purported to show the whole map on the screen. Mr. President, we've been rather harshly accused of falsifying maps, and we deny that claim. But I would note that the original Big Map had the Annex 1 map line clearly depicted on it, while the image that Council projected yesterday, which is on the screen, inexplicably deleted that line. We can, however, see from this map the scope of the territory which the parties' arguments in the original case addressed. And in fact, as Ebru, Thailand's experts, stated in their first report attached to Thailand's written observations, and I quote, "The evidence before the court mainly concerned the 7 kilometers by 12 kilometers areas mapped by Professor Schimmerhorn in the vicinity of the temple," end of quote. Thus, Council's attempt to limit the vicinity to a tiny part of the Annex 85D map is contradicted by Thailand's own experts. Now, the second argument raised by Council foreshadowed a point that Professor Pillay raised later, namely that the area from which Thailand withdrew its troops is comparable to the area covered by the partial reproduction of the Annex 85D map, and this argument doesn't work either. The Council of Ministers map was not based on any reasoning whatsoever, whether the Annex 85D map or the watershed line. There was no rationale with respect to the judgment or the pleadings of the parties in the Council of Ministers resolution or memorandum explaining the rationale for the yellow and red lines. And there's no relation between the Council of Ministers map and Annex 85D. Lastly, Council found significance in the fact that the Court published this smaller extract with the volume of pleadings. Well, that may be so. But the fact remains that the Court, as I said, did not refer to the Annex 85 map or the partial reduction or reproduction of it in its judgment, making it difficult to see how the Court could have relied on it. It doesn't even mention it. And to the contrary, the Court clearly said that given the grounds on which the Court based its decision, it was unnecessary to consider whether the Annex 1 map line corresponded to the watershed or not. In short, the watershed lines depicted on this map here, and it's the red line that Professor Pellet and Madame Miron trying to equate with the Council of Ministers line. It's the red wavy line on the left. And those watershed lines depicted on this map were completely irrelevant to the Court's decision. Now that brings me to Thailand's argument about the famous 4.6 kilometer area, and in turn to Cambodia's answer, at least on a preliminary basis, to the question that Judge Youssef posed to the parties yesterday. Madame Miron argued that the dispute dealt with by the Court in 1962 had nothing to do with the 4.6 square kilometer perimeter. But as I shall show, the area in question arises directly out of maps that the parties placed before the Court in the original case. And it can be identified, this area can be identified by carrying out an exercise that Thailand's own expert in the original case, Professor Schermerhorn, recommended be done in his report that was attached as Annex 49 to Thailand's counter-memorial in the earlier case. To place the matter in context, the claims of the parties in the original case need to be recalled. As the Court observed in its judgment, Cambodia principally relied on the Annex 1, on the line appearing on the Annex 1 map, while Thailand argued in favor of a frontier running along the edge of the escarpment south and east of the temple. This was Thailand's watershed line. In his expert report, Professor Schermerhorn stated that he had been requested, and presumably by Thailand, since he was appearing on behalf of Thailand, he had been requested to make a comparison between the watershed map of Thailand's experts and the Annex 1 map. And after he adjusted the scales of each of these maps, the watershed map of Thailand and the Annex 1 map, after he adjusted those scales so that they matched, copies of those maps were included in his report at Annex 49. And as Professor Schermerhorn then noted, and I quote, "For comparison, both copies should be put on top of each other. Overlay the Annex 1 map to the Thai expert's watershed line map, or vice versa. I confess I don't recall which way it was." And that is precisely what Cambodia attempted to do on the map that was included after page 76 of its response. A copy of that map now appears on the screen, with the Annex 1 map line highlighted in green and the watershed line, according to Thailand's experts, in red. And to avoid being taken to task, I hasten to note that Cambodia put the colors on this map to highlight the lines, make them easier to see. Now, IBRU's second report criticizes Cambodia's approach because Cambodia did not align map sheet 3 with the registration crosses provided on map sheet 4 when it did the overlay exercise. Somewhat confusingly, however, Thailand's further written explanations state that the registration points were not on sheet 4, but sheet 3. There's a contradiction there. But be that as it may, IBRU produced its own overlay, which now appears on your screen. And once again, we've colored the lines to make them easier to see. Annex 1, the green, Thailand's original watershed claim, the red. According to Ebru, a correct application of Professor Schermerhorn's procedure produces an area of 4.2 square kilometers, not 4.6. Now, Cambodia does not dispute Ebru's calculation. But I'd note in passing that it's Thailand itself that is consistently referred to the disputed area as comprising 4.6 square kilometers. And in tab 26 of the folders, the court will find a number of publicly available, readily accessible, with a push of the button, English language reports emanating from Thai and third-party sources attributing the 4.6 kilometer to Thailand. The important point is that on both maps, the map that we prepared after page 76 of our response and Ebru's correction of that map, on both maps, both overlays, the Annex 1 map line and Thailand's watershed line intersect to the east and the west. You can see that, and the area in between is the area falling between the lines relied upon by the parties in the original case. Now, obviously, in its judgment, the court pronounced in favor of the frontier as mapped on the Annex 1 map, the green line. In response to Judge Yusuf's question, therefore, in Cambodia's view, and relying on maps that were presented in the initial or original procedure, the territorial extent of the vicinity of the temple mentioned in paragraph 2 of the dispositif has to be understood, of course, in the context of that paragraph, but it seems to us to correspond to the area lying south of the Annex 1 map line up to the intersection to the east and west of the temple with Thailand's claimed watershed line. Of course, Thailand's claimed watershed line was not accepted by the court in 1962. But that, in the original case, could be viewed as the area of overlapping claims. And that's what we suggest is meant by the vicinity in paragraph 2 of the dispositif. But of course, Cambodia reserves the right to supplement this answer in writing pursuant to the timetable that the President mentioned. Now, the final issue regarding maps that I need to address concerns Thailand's claim that the Annex 1 map line is difficult to transpose onto a modern map of the area and on the ground. Here I have to say that the arguments raised by Thailand's counsel raise serious questions as to whether Thailand's real aim is to revise the original judgment. Madame Milon led off by saying that Cambodia had not produced any proof that the map said to have been attached to Cambodia's pleadings in the original case is the real Annex 1 map. Well, let me try and put my friend's mind to rest on this point. Map on the screen, and I will use Madame Milon's slide of it, is indeed the real Annex 1 map. All you have to do is to proceed to the court's archives where the map can be found and look at the reverse side of it. Turn it over, because there's a label on the back that clearly indicating that this is the map that was attached as Annex 1. Now, as for transposing the Annex 1 map line on a modern map, counsel argues that the most natural way to do this, the most natural method, would consist of identifying the watershed line, since she says that was the intention of the authors of the map. But, Mr. President, that's nothing less than a plea to revise the judgment. If you want to use the Annex 1 map line, don't use the Annex 1 map line. Turn it in now in the process of transposing it onto a modern map or on the ground. Transpose it back into a watershed line, which Thailand lost in the first case. It should not be necessary to recall that the court stated with the utmost clarity that the acceptance of the Annex 1 map caused it to enter into the treaty settlement between the parties and to become an integral part of it. Now, I apologize for repeating what I said on Monday, but Thailand's counsel have avoided dealing with the issue, because in the judgment, the court also stated that there's no reason to think that the parties attached any special importance to the line of the watershed as such, and that it was unnecessary to consider whether at Preah the line as mapped on the Annex 1 map, does in fact correspond to the watershed in this vicinity. And to intimate now that the Annex 1 map should be transposed along the watershed and that it has no practical value because of the alleged difficulties in transposing it on a modern map, in other words, a map that didn't even exist in 1962, is fundamentally misguided if we're interpreting a judgment rendered in 1962. All of those colorful lines that counsel displayed as a result of Ebru's attempt to transpose the Annex 1 map line onto different modern maps or to make various transposition adjustments are utterly irrelevant. The court was not asked to transpose the line on a modern map in 1962, and nor was it asked to fix the boundary on the ground. And the same, with respect, holds true now. None of these brightly colored lines was at issue 50 years ago. In 1962, the court did not delimit the boundary. It recognized that the parties had accepted that the frontier in the region of the temple had already been delimited as of 1908. And any problems relating to transposing the Annex 1 map line on the ground may, if at all relevant, be taken up under the 2000 MOU, another instrument that post-dates the judgment, because that instrument concerns the survey and demarcation of the boundary. But none of that is germane to the present case. And the real question which Thailand has not answered, is how Thailand can be considered to have withdrawn from Cambodian territory in the vicinity of the temple if its forces are still on Cambodia's side of the frontier line previously delimited and accepted by the parties. Mr. President, that concludes my presentation. I thank the Court for its attention, and I would ask if you could give the floor to Sir Franklin, please.
Thank you very much, Mr. Bundy, and I give the floor to Sir Franklin Berman to continue. You have the floor, sir.
Mr. President, you wisely admonished us yesterday to confine our second round argument to responding to the essential points made by our opponents and to finish, if possible, in less time than the full ration allocated to us. I can promise you the first, and I'll have to do the best I can towards the second. Mr. President, I don't lay claim to the eloquence of our opponents, but sometimes silences can be more eloquent than words, so I begin with two of the graver silences we observed in our opponents' extensive oral pleadings yesterday, and I can only hope you won't rule me out of order if what I'm responding to is the absence of argument. But these silences are significant, and their significance needs to be exposed. The first and most glaring silence is over the Council of Ministers resolution of July 1962. The Court will remember it. Mr. Bundy's referred to it. It's the one on the implementation of the Court's 1962 judgment. It is, of course, Thailand's own Council of Ministers, not ours. I can hardly be accused of not having emphasized this document, its late appearance into the light of day, or its significance for our present proceedings. So there's something quite astonishing in the almost complete absence of response from the Thai side. The document had a glancing mention by the agent, by Professor Pillay. Madame Miron flashed on the screen in the middle of a dazzling array of other cartographic slides, the small map attached to the supporting text which the Council of Ministers had under discussion, but the Court heard no response to the whole series of rather damning conclusions we drew from this document, and neither did we. I can't, as it were, go through all the omissions. The most striking of them was a total absence of comment, as Mr. Bundy said, on the yellow line on the illustrative map, and in that context on the proposal of two alternative methods for implementing the judgment, two widely differing methods of defining what Thailand claimed to be the vicinity of the temple, And in the context of the choice between those two methods, the absence of any description of even the most rudimentary kind of why either or both of those two very different methods was indeed thought to correspond to what the court had decided, which remains a principal element in the whole case Thailand now brings before the court. For Madame Miron now to announce to us ex post facto that the more parsimonious of these two methods corresponds in effect to the Cambodian version of the watershed line is, shall we put it delicately, somewhat far-fetched. But Mr. Bundy has already dealt with this. It would, however, have been helpful to have had some precise citation of exactly where in the 1962 judgment Thailand says that the court laid down at the boundary, which of course Thailand now says the judgment didn't establish, where Thailand says the court laid down at the boundary should follow the Cambodian watershed line. Mr. President, the court will have to draw its own conclusions from this total failure to comment or to explain. We have set out at length, on the first occasion we had the opportunity to do so, the conclusions that arise from this crucial document. Thailand has had ample time to reply and has chosen not to do so. I conclude by saying that we trust, and I hope this is not an unworthy remark, that Thailand is not holding back its comments until the final session tomorrow, with an eye to depriving us of our opportunity to come back on it. That really would be to deny Cambodia a legal process in due and proper form of the kind of which the Thai agent unjustly reproached the court yesterday. Mr. President, the second crushing omission is any argument on the meaning of withdrawal, what it means to withdraw. We pointed out on Monday that this was the cardinal question for the interpretation of the judgment, and specifically for the interpretation of that paragraph in the dispositif to which Cambodia's request for interpretation was expressly directed. We pointed out also that withdrawal necessarily implied a destination as well as a starting point, and that the only reasonable way to interpret the second paragraph of the dispositif was as a requirement to withdraw from Cambodian territory onto Thai territory. The destination is crucial, but it received not a word of comment from our opponents yesterday. So what are we to think? Do they accept our interpretation? Or do they want us to understand that the court was perfectly content for Thailand in implementing the judgment to move its military or police forces, etc., away from the temple and to place them in some other part of Cambodian sovereign territory, somewhere else? It sounds absurd, since, as they would say in France, des deux choses l'une. It has to be the one or the other. Connected with that is what I would call another absurdity resulting from yesterday's argument, but let's be tactful and call it a circularity. Thailand's argument on withdrawal is, we have decided that we complied with what we want to interpret the second paragraph of the dispositif to mean, and because we have complied, there is no dispute. It sounds like a caricature, but it's not. The court can see that at paragraph 19 of Professor McRae's pleading yesterday morning. And it is, of course, connected with the assertion, an assertion which underlies the Council of Ministers resolution that Thailand has an untrammeled unilateral right to determine the limits of an area laid down but not defined by the court. And now we have heard that argument, assertion bolstered by an additional argument yesterday that there's no rule of international law requiring a party to consult with the other party on the implementation of a judgment binding the two of them. To which we can only reply that there is no rule of international law either which requires the second party to accept the first party's unilateral interpretation if it's wrong. I can't fail to draw attention at this point to the stratagem Thailand's council use to arrive at this self-justifying result. They rewrite the terms of what the court said. It's not the only time they do so, and I will refer to at least one other later. Thailand consistently reconstructs the second paragraph of the dispositif to make it read something like, Thailand is under an obligation to withdraw any military or police forces, etc., from the temple or its vicinity. And then, of course, you have on Cambodian territory. That sounds beguiling at first, but it's not what the court said. What the court actually ordered Thailand to do was to withdraw any military or police forces, etc., stationed by her at the temple or in its vicinity on Cambodian territory. The words are not the same, and when you look at the words actually used, therefore, you can see that the primary function of the reference to the temple and its vicinity was to identify which Thai elements the court had in view. Those which Thailand had at the time stationed in and around the temple, and nobody knew exactly what they were, so the court says any. But the paragraph does not expressly define the destination. It leaves that to be inferred. The primary obligation there remains intact. It is to withdraw. And there is nothing there to suggest or to imply that the destination of that withdrawal should be understood as being just a little bit on the other side of a self-defined vicinity. And that is why, once again, Cambodia insists that on the dispositive, as worded by the court, the natural meaning of withdrawal, taken in conjunction with the reference to Cambodian territory, has to be out of Cambodia and into Thailand. And that has to be understood in turn in connection with the first paragraph and the essential reasoning which underlay that paragraph. We said that on Monday, and there has been no Thai answer. Well, having mentioned that one insidious rewriting of what the court said, Mr. President, perhaps it would save time to go on at once to two others. We were told, with that categorical assurance that characterizes Thailand's pleadings, that the first and second paragraphs of the dispositif simply accept and, as it were, enact Cambodia's third and fourth submissions, whereas the first and second submissions were rejected. Well, they didn't, and they weren't. Let me begin with the second paragraph of the dispositif and the third Cambodian submission, which is supposed to correspond to it. That's on the screen. What Cambodia actually asked for, and you can see that at page 11 of the judgment, is to adjudge and declare that Thailand is under an obligation to withdraw the detachments of armed forces it has stationed since 1954 in Cambodian territory in the ruins of the temple of Phra Vihear. So you can see at once, Mr. President, that there was a whole series of differences between that and what the court in due course decided. And some of these differences go directly to the points Thailand has been trying to make here. Notably, the whole great concentrated attempt to have the case confined ex post facto and without justification to the temple ruins and nothing more. What does Thailand want us to think? That the court was seriously negligent in copying out Cambodia's submission from one place to another? Or could it just be that the court was making a deliberate decision of its own, intended to have an autonomous meaning of its own in context, i.e., in the context of the dispositif of the 1962 judgment as a whole? Which brings me to the second Thai distortion, which this time I can only hope is purely accidental. In addition to telling the court wrongly that the second paragraph was simply the Cambodian submission, Professor McRae also would have the court accept that not only the second but also the first paragraph was no more than the Cambodian submission. And this time there is indeed a close textual correspondence. But Professor McRae has forgotten the three little words. The three key little words finds in consequence, the three key words that link the two paragraphs together, they were not in the Cambodian submissions. They were consciously, and one must assume deliberately, added by the court. The words are there, though, and we can't possibly make the assumption that the court chooses to add a phrase to the dispositive part of a judgment without doing so for a reason and for a purpose. And we say that the obvious reason and purpose is to link the first two paragraphs firmly together. But even more than that, to condition the sense of the second by reference to the first. Professors Crawford and McRae seemed actually to like my symbiotically linked, so I'm happy to stay with it, and to reiterate in that context Cambodia's formal submission that the word territory, as used by the court in each of the first two paragraphs of the dispositif, must be understood as having the same meaning in both paragraphs. We apprehend that Thailand now accepts that, which is welcome, and I refer to paragraph 21 of Professor Pillai's pleading yesterday afternoon, but that does not dispose of the dispute between the parties over the link between the two paragraphs, because we say that the entire logic of the two, as well as their express wording, makes the second subordinate to the first, whereas Thailand still tries to make the second prevail over the first. Back, in other words, to Thailand's whole attempt to confine the entire judgment to the temple ruins and their immediate surrounds, back to the Council of Ministers' arrogation to themselves of the sole right to define the vicinity, ostensibly for withdrawal purposes, but actually for the surreptitious creation of a boundary for sovereignty purposes, as I demonstrated to the court on Monday by a close textual analysis of the Council's decision. And then forward to the Thai maps, the ones Mr. Bundy has just referred to, which shamelessly portray a confusing series of variants of that line as the international boundary. And that's the way Thailand describes it in its note of 2008 to the UN Security Council. Mr. President, my next theme must be the continuing nature of the withdrawal obligation. I drew attention on Monday to Thailand's equivocation on this key issue. So far as we can see, they continue to equivocate. The closest we got to a statement of Thai position yesterday was that although the obligation is continuing on day 2 after the judgment, after troops have withdrawn and time has elapsed, then the notion of withdrawal is no longer relevant. And there may be other obligations not to enter a territory, but it is totally artificial to link it to any notice of withdrawal. So at a given moment, undefined of course, Thailand acquires what in the game of Monopoly would be called a get-out-of-jail-free card. Because at that moment, undefined, what used to be a question of withdrawal can no longer be given a meaning. Any question about it is not withdrawal, it's execution. And of course, Thailand has clearly indicated, through the mouth of its agent, that it would vigorously refuse to consent to any such issue being submitted to this court. So this is not a position, Mr. President, it's a contortion. And because Professor McRae is fixated on the question of execution, he produces his rather sad example of a stray accidental crossing by a single Thai soldier, which demonstrates nothing more than that our opponents obstinately refuse to take on board that what we have posed is a general question of interpretation. And I find myself returning to the point I've had to repeat ad nauseam, that interpretation is different from execution and logically precedes it. Unless Thailand now says plainly that it accepts the simple proposition that the withdrawal obligation, as specifically enunciated by the court in the context of this dispositif, must be taken as having a continuing character, there unmistakably is a dispute between the parties on this question, and it undeniably falls within the court's interpretative jurisdiction. So let me come finally to the last of Thailand's rewritings of the court's dispositif. Although this one is both more subliminal and more pervasive, almost the whole of Thailand's pleading yesterday was constructed as an argument addressed to the text of a different 1962 judgment, one which reads, "Awards the sovereignty over the temple of Prayer Vihir to Cambodia." That is the judgment beloved of our opponents, one which is entirely limited to the temple ruins, precincts, or just the ground on which the temple stands. But it is not our judgment. It's not what the first paragraph of the dispositif says, not at all. And we pointed out as long ago as the original Cambodian request for interpretation that there is not a hint in the judgment of 1962 of the existence of a separate territorial title over the temple, which the court then attributes to Cambodia. Yet Thailand continues to argue as if that is what the judgment did, that they know as well as we do that the court decided that the temple is situated in territory under the sovereignty of Cambodia, and that because of that the temple appertains to Cambodia, and the court chose also to make that its primary finding. That is what the court chose to do. One more distortion, Mr. President, and then I can move on to more constructive ground. Counsel for Thailand suggested to the court yesterday that Cambodia was inadmissibly asking the court to interpret the reasoning in the 1962 judgment. Well, that is pure invention. It shouldn't be necessary for me to put up once again the slide we showed on Monday, which compares the text of Cambodia's question with the text of the dispositif, but I have to do so. It's plain as a pikestaff that the question addresses itself to the dispositif and asks that the dispositif be interpreted in the light of the reasoning, so far as it is necessary to do so. Where our opponents say reasoning, of course, they mean the map. I challenge them to draw the court's attention to any place from the request onwards where Cambodia asks the court to interpret the map. What Cambodia asks the court to do is to interpret the dispositif in the light of the map, because the court's treatment of the map is precisely the kind of essential reasoning which the court said in Cameroon against Nigeria fell within the scope of interpretation under Article 60 of the statute, and thus under the court's duty to interpret at the request of a party. Having reached that point, Mr. President, members of the court, I can now return to what I had already described on Monday as the one single point on which rests Thailand's whole response to the admissibility of Cambodia's request, i.e., that Cambodia is trying to gain now what it could not gain at the time. As I said on Monday, this argument appears in two forms, but it's the same point. With the court's leave, I won't go further into the variant that says anything to do with the boundary, even very close to the temple, goes beyond the dispute that had been submitted to the court. That's just another version of the court awarded sovereignty over the temple to Cambodia trope, which I have just dealt with. Mr. Bundy has moreover shown, by reference to contemporaneous documents, that the present disputed zone had already been delineated then by the time of the 1962 judgment. For my part, I have to insist on two things. The first is that whenever our opponents get around to focusing on how the court itself defined the dispute, even if you like to call it the sole dispute, before the court, they always elide the fact, the central fact, that the court defines it as a region. The subject of the dispute submitted to the court is confined to a difference of view about sovereignty over the region of the temple of Preah Vihear. That's what the court said at page 14 of the judgment. And the second is the reason why the court defines the dispute that way. Because Thailand, so says the court itself, had replied to Cambodia's claims by affirming that the area in question, not the temple, the area in question, lies on the Thai side of what? Of the common frontier between the two countries, and is under the sovereignty of Thailand. Yes, consequence of the frontier. So says the court, and it is simply not admissible for a party in these proceedings to try to erase the court's conclusion in order to substitute its own. Second variant of the argument, Mr. President, is the one about the map. That again comes in two forms, and we heard them both yesterday. The one says the court didn't rely on the map. The other says, in any case, it decided the case on other grounds. I described the latter as ludicrous on Monday, and nothing we heard yesterday leads me to change that description. But now I do have to devote a little more time to it than I did then, because Thailand really is guilty of indefensible selective quotation in its treatment of this matter. I'm going to confine myself largely to Prince Damrong, because we all agree that that is much the most significant of these other matters. If the Prince Damrong incident doesn't stand up, then nor do any of the others. So let us look seriously at what the court said in this regard. The court begins by looking generally, that's at pages 29 to 30 of the judgment, at the whole category of administrative acts. And that forms the framework for its consideration of this category of evidence. And it begins by saying, it was specifically admitted by Thailand in the course of the oral hearing that if Cambodia acquired sovereignty over the temple area, by virtue of the frontier settlement of 1904, she did not subsequently abandon it, nor did Thailand subsequently obtain it by any process of acquisitive prescription. Note that the court doesn't refer to the temple area. It's even clearer in the French text, zone du temple. And I cite it happily, even though it is part of the proceedings before the court came to its judgment, because this is the court describing an element that is clearly key in its reasoning. Not a case of trying, as Thailand always does, to replace what the court said with the sayings of the parties. And having pinned down that admission, that's what it is, by Thailand, the court then continues as follows. Thailand's acts on the ground were therefore put forward as evidence of conduct as sovereign, sufficient to negative any suggestion that under the 1904 treaty settlement, Thailand accepted a delimitation, note the words, delimitation, having the effect of attributing the sovereignty over Preah Vihear to Cambodia. It is therefore, again, therefore, from this standpoint that the court must consider and evaluate these acts. The real question is whether they suffice to efface or cancel out the clear impression of acceptance of the frontier line at Preah Vihear to be derived from the considerations already discussed. And it is in this connection, again the court's own words, that the court then goes on to its two short paragraphs on Prince Damrong. That's at pages 30 to 31. The court then goes on to discuss the remaining relevant facts, which it does in another 4 paragraphs, which takes us to the middle of page 32. Page 30 had given us the top, and now we have the tail. The court will now state the conclusions it draws from the facts as above set out. Even if there were any doubt as to Siam's acceptance of the map in 1908, and hence of the frontier indicated thereon, the court would consider, in the light of the subsequent course of events, that Thailand is now precluded by her conduct from asserting that she did not accept it. The court, however, considers that Thailand in 1908-1909, note the dates, a long time ago, more than a century, did accept the Annex I map as representing the outcome of the work of delimitation, note, delimitation again, and hence recognize the line on that map as being the frontier line, and then the effect of which is to situate Preah Vihear in Cambodian territory. The court considers further that, looked at as a whole, Thailand's subsequent conduct confirms and bears out her original acceptance, and that Thailand's acts on the ground do not suffice to negative this. Both parties, by their conduct, recognize the line and therefore, in effect, agreed to regard it as being the frontier line. That's what the court says at pages 32 to 3. Mr. President, against that background, clair comme l'eau de roche, one might say, it really is not good enough for Thailand to come to the court and say that in 1962 what Professor Crawford called the other consequences were decisive in answering the one question the court had to answer, or indeed even worse, that Prince Damrong's visit was a separate reason for the judgment, or for Professor Pellet to claim that the visit by Prince Damrong in 1930 a constitué l'un des arguments cruciaux ayant conduit la Cour à reconnaître la souveraineté du Cambodge sur le Temple. Oh, just to add, Mr. President, before I forget, that we challenged Thailand on Monday to say whether their cavalier approach to the court's treatment of the map meant that it was now Thailand's position that it could now deny that Siam had accepted the map and the line on it, with the result that both entered into the treaty settlement and became an integral part of it. Once again, not a word in reply. So, Mr. President, I can pass now to the second form in which Thailand's one sole argument is couched, that the court never relied on the map. This time, at least, it comes with a small concession attached that the map may hold explanatory value in respect of the operative part of the judgment. That, at all events, is how Thailand puts it in rather gingerly fashion in paragraph 3.33 of the further written explanations. Now, I don't think we heard it repeated in the oral argument yesterday, What we did hear in the oral argument was something along these lines, that although we're talking about a map with a frontier line on it, this doesn't mean the court looked at the line on the map, that the court didn't adopt the map as a specification of the frontier line, that although Thailand was no longer able to deny what the map said about the temple, in respect of the other question, a separate, unrelated question, the question of the frontier, that the map could have answered, the map gives no answer. Mr. President, this is yet another farrago. So let me once again try the patience of the court by recalling with precision what the court actually said. This is not extrapolation, it's not interpretation, it is neither intra nor ultra petita, neither sub petita nor super petita. It is just a simple recapitulation of what appears in the judgment. In other words, of the way the court reasoned in moving towards its conclusions in the dispositif. If we have omitted anything, we will happily stand corrected by our distinguished opponents. The main steps in the court's reasoning were laid out in Cambodia's request for interpretation at paragraph 39, in detailed citations of the judgment with all the references. Some of these repeat what I've already said above, and it would be better for me not to repeat them once more. But we put them on the table 2 years ago for all to see, and I want to repeat just one, which is drawn from what I said to the court on Monday. The court considers that the acceptance of the Annex I map by the parties caused the map to enter the treaty settlement and to become an integral part of it. It cannot be said that this process involved a departure from, even a violation of, the terms of the Treaty of 1904, wherever the map line diverged from the line of the watershed. For, as the court sees the matter, the map, whether in all respects accurate by reference to the true watershed line or not, was accepted by the parties in 1908 and thereafter as constituting the result of the interpretation given by the two governments to the delimitation which the treaty itself required. In other words, the parties at that time adopted an interpretation of the treaty settlement which caused the map line, insofar as it may have departed from the line of the watershed, to prevail over the relevant clause of the treaty. And now I must go back to another point I had already mentioned. While steering clear, Mr. President, of your injunction against repetition, but it is an important point, and yet another one to which Thailand has simply failed to respond. Thailand's counsel seemed to think that simply by reiterating over and over again, I lost count in the end of the number of times, that the court in 1962 declined to include in its findings on the Annex I map in the dispositif, that they thereby prove that the court refused to decide on the status of the map at all. I showed with some care on Monday what in our submission the court did mean, and today I've given the court, I hope, ample citation to show the court doing nothing other than deciding on the status which the parties had given to the map, but doing so is the essential element in its reasoning on which the dispositif is then duly based. If Thailand continues to insist, in the face of what the court actually said, that la frontière attend toujours d'être reconnue, and that there has not been une délimitation frontalière, ni globalement, ni dans le secteur de l'Angrec, ni dans la zone du Temple, if it continues to insist on that, it will show that its only real interest is to divert attention away from the terms of the judgment as such. Mr. President, I end where one should end, with the question Cambodia has put to the court for interpretation, which Professor McRae took aim at yesterday for a series of reasons, some of which we found hard to follow. He seemed first to be objecting that the question had stayed the same throughout these proceedings, from the request itself until today. That can't surely be so. Had we changed our minds, one might have seen some scope for objection, but we haven't. Perhaps he was mixing up the question itself with the dispute between the parties that generated the question. We have indeed been discovering, as these proceedings move on, that the Thai position is even more extreme than we had thought, so that what I called earlier the linked series of disputes between the parties is even more extensive than had earlier been allowed to appear. Vide the Council of Ministers resolution, which we saw so late. Vide some of the oral argument we heard yesterday. But the question for interpretation remains the same. It's unchanged, and Professor McRae affected to have difficulty in understanding it. He took issue with its form, which he said was a statement more than a question. But if one looks through the smallish list of interpretation cases brought before the permanent court and this court, one can see that sometimes the applicant state asks an open question, sometimes it puts forward a proposed interpretation, which it asks the court to endorse. The court has never had difficulty with a request in either form. Next, he complains about the way he says we now try by a ruse to bring in the first paragraph of the dispositif. But the link between the first and second paragraphs has always been there. And as I noted, the question has remained the same. Thailand's approach towards interpretation in this context now seems to be not only that you have to interpret the dispositive part of a judgment in isolation from the reasons that sustain it, but that you have to interpret each paragraph in a dispositif in isolation from the others. That goes against all tenets of interpretation in international law, and it makes no sense. It makes no sense in principle, and it makes no sense at all where you have paragraphs that the court itself has explicitly linked together. I've already made my submission on behalf of Cambodia that territory must have the same meaning in both paragraphs, and my further submission that the interpretation in the second must be controlled by its interpretation in the first. Either Thailand agrees with both of those submissions, or we definitely have a dispute about the link and the hierarchy between the two. Professor McRae accuses us of suddenly trying to manufacture a dispute over the definition of vicinity in the second paragraph, but we've never put the matter that way, framing instead a question very specifically about how to understand the meaning and scope of the withdrawal obligation. In any case, Judge Yusuf has now put a penetrating question on the very subject of the interpretation of that word, to which we've given a first oral response by Mr. Bundy. We will elaborate as necessary in writing within the time limit laid down by the court. And finally, Professor McRae says that our question is essentially flawed because it presupposes the answer. But I've already explained that there's nothing out of the ordinary in framing a question for interpretation by the court in terms of a proposed interpretation which the court is requested to endorse. And Professor McRae is only able to arrive at his own criticism by a far more severe case of question begging than he has accused us of, in that his whole proposition depends on denial in the most outright terms that the court decided anything at all about frontiers or the Annex I map. I've taken the court through the relevant passages in the judgment and shown that that approach is simply unsustainable in terms of what the court actually said on the subject. So Professor McRae's proposition becomes one that depends entirely on establishing an impermeable distinction between decisions of two kinds, that a decision placed in the operative part becomes a creature of a categorically different kind from a decision contained in the reasoning, even if the reasoning is, as the court has held, inseparable from the dispositif, and thus an essential part of the process of interpretation. Mr. President, that is arid formalism of the worst kind. I ask the court to reject it, both because it denies the normal process of legal reasoning in reasoned judgments, and because it contradicts what the court itself has said on the subject. All that Cambodia is asking the court to do is to interpret the dispositif in the light of the essential reason behind it. That is a perfectly normal process which is not at all difficult to understand. Mr. President, that concludes my pleading. Might I ask you now to give the floor to Professor Sorel?
Thank you very much, Sir Franklin. Et je passe la parole à Monsieur le Professeur Jean-Marc Sorel. Vous avez la parole, Monsieur.
Sorel has the floor. President, ladies and gentlemen of the court, in attempting to respond to the arguments of Thailand yesterday, Cambodia would like to reverse the presentation that was offered to you during Monday's pleadings. Cambodia was discussing the vital connection between the reasons, the grounds of the 1962 judgment and its operating clause, so as to give rise to the consequences that Thailand would deny. But this time we would like to swim back upstream and indicate the Thai responses to the arguments, or rather their lack of response, before confirming the inseparable nature of the essential grounds and the dispositif of this judgment. So it is deliberately that Cambodia is going to go back over the points already mentioned in the previous pleadings, but in the light of the absence of a Thai response. As the Thai agent rightly indicated, the present dispute necessarily is highly fact-intensive. We would like it to be a bit more law-intensive. So we must go back to the impossibility of a unilateral definition of a frontier in contradiction to the grounds, the absence of a relevant distinction between a territorial and a border dispute, the true meaning of the agreement of June 2000, and the reversal by Thailand of the court's reasoning, and the temptation to recast the 1962 judgment, and to observe finally that Thailand cannot come up with a satisfactory response concerning the connection, and cannot give a satisfactory interpretation of what the court decided with binding force in 1962. First of all, the impossibility of unilateral definition. The response Cambodia was hoping for has not been furnished. The only response to this unilateral line decided by the Thai cabinet in 1962, and it's really only semantics. In other words, the unilateral request for a listing of the temple on the UNESCO World Heritage List, except that the temple already belongs to Cambodia. Nothing outrageous about that. And Professor Pillay says perhaps it would have been preferable for the two parties to agree expressly, but in the context of the times, in view of the trauma that the judgment had caused in Thailand, it would have been asking a lot of them. And moreover, to my knowledge, says Professor Pillay, there is no rule whereby the parties in a case must negotiate the terms and conditions of the implementation of a judgment, and adds that it would have been possible to seize the court with an incident in implementation. And this is worth dwelling on, because it is the only response provided to the question of a unilateral definition of the limit, and I shall spare Thailand any reference to a frontier for the moment, as imposed by Thailand. Nothing more. We still do not know how legally a state can impose such a limit on its neighbour without cooperation, and whereas the judgment which led to the drawing of the limit says exactly the opposite in its grounds. But the explanation is coming, because they then explain in a supremely condescending style that Thailand was very upset with the judgment, that they had suffered trauma, which Cambodia can understand, and that more should not be required of them. In other words, bad loser is what they call it in plain language. Okay for a kid, not so for government. If we continue, we hear the explanation that a state does not have to negotiate the terms and conditions of a judgment in which it has lost its case. True, it doesn't negotiate them, it implements them. And once again, according to Professor Pillay, if the state is not happy, then he can always bring to your court the incident in implementation. This is an unknown category as we speak, the only possibilities being, as is well known, revision or interpretation, because a judgment is final without appeal. So here we have a series of strange assertions proving that the parallel world is not necessarily on the Cambodian side, but no doubt for Thailand this is a brave new world. In other words, science fiction, or to say the least, futurology. And yet we still do not know why, apart from a fit of pique on the part of a state, how a state can set a limit to its territory in contradiction to a judgment which says the opposite of what that state is doing. Now to the similarity between a territorial and a frontier conflict. Regarding the Thai obsession with circumscribing this dispute to a territorial dispute having no impact on the frontier, The response provided this time is truncated. Madame Miron, in her pleading, admittedly does announce a coming demonstration regarding this dispute concerning territorial sovereignty and not delimitation, but no demonstration is forthcoming because point 2, at the end of the day, talks about identification of the subject of the dispute in the form of map-based evidence, which arguably is not the same thing. Professor Pelley cites a few examples, but they are isolated and of a particular and different nature. The North Sea continental shelf case, where everybody knows that what was being called for were the principles of delimitation, not delimitation in itself. The sovereignty over frontier lands case, Belgium, Netherlands, where the enclaves had already been delimited and they were simply to be assigned, or the Pedro Branca case, islands and tidal elevations. In other words, subsequent delimitation, but nothing on a conventional case like this one. And yet the jurisprudence of your court in this respect is completely unequivocal. Cambodia has quoted the sovereignty over frontier lands case, but it is worth going back to that case after, the border dispute case, 1986, because after explaining the discussions between the parties, the court says, in fact, however, in the great majority of cases, including this one, the distinction outlined above is not so much a difference in kind, but rather a difference of degree as to the way the operation in question is carried out. The effect of any delimitation, no matter how small the disputed area crossed by the line, is an apportionment of the areas of land lying on either side of the land. In the present case, it may be noted that the special agreement in Article 1 refers not merely to a line to be drawn, but to a disputed area, which it defines as consisting of a band of territory encompassing the region of the Bili. And it is precisely after that that the court indicates that the result necessarily is to draw a frontier. And in Libya-Chad, the court further indicates it will be evident, and I quote from the preceding discussion, that the dispute before the court, whether described as a territorial dispute or a boundary dispute, is conclusively determined by a treaty to which Libya is an original party and Chad a party in succession to France. The court's conclusion that the treaty contains an agreed boundary renders it unnecessary to consider the history of the borderlands claimed by Libya on the basis of title inherited from the indigenous people, the Senussi order, the Ottoman Empire and Italy. Moreover, in this case it is Libya, an original party of the treaty, rather than a successor state, that contests its resolution of the territorial or boundary question. So these examples of territorial or boundary disputes, whether they concern large extents of land or narrow strips, areas, zones, regions, give rise to a process, the upshot of which is to draw a frontier. Now to the true meaning of June 14th, 2000. The question of the 14th June 2000 memorandum continues to feature Thailand in the role of the contortionist, but we still don't have a clear answer. Professor Pelley indicates that this agreement, as its name indicates, defines the legal framework to be applied in determining frontiers. Now, yet another paraphrase in reference to a delimitation to come. And though this may seem pointless, it is no doubt relevant to go back to the exact wording of the name in the face of this refusal to consider the agreement for what it is. Memorandum between the government of the Kingdom of Cambodia and the government of Thailand concerning the survey and demarcation of a land boundary. In another manner, Professor Crawford then indicates that the court did not transpose the map in 1962. It did not consider it necessary to do so because the only question was who the temple belonged to. Once again, this comes somewhat as a surprise. It's not a matter of transposition, but recognizing a delimitation. Transposition arises in conjunction with demarcation, not delimitation. Now, I wouldn't like to upset Thailand's feelings, but Cambodia does strongly stress the distinction between delimitation and demarcation, and for a very simple reason. Since the 2000 memorandum is indeed a treaty which provides for demarcation, and since Thailand does not consider that it exists following, despite confirmation by the court in 1962, perhaps it can indicate what precisely is this delimitation. Because if you sign a demarcation agreement, then this presupposes a pre-existing delimitation. So presumably it must exist. And in the same way, Thailand's agent says that the agreement was signed after the initial encroachments on the Thai territory. But is it not then surprising that Thailand should shortly after sign a memorandum, nor that it did not protest against the pagoda built in 1998 by Cambodia on a territory which was supposed to belong to it and which it was supposed to be in control of? The plot thickens. Now, concerning the famous and mysterious map L7017, they now say that it's not mentioned in the agreement of June 14, 2000, because it is not a bilateral document, and that consequently it cannot be invoked as establishing title. That's a weak explanation, if it is an explanation at all, because Thailand's documents themselves prove that this map is indeed considered as representing a true frontier, as my learned colleague Rodman Bundy pointed out. So not only does Thailand persist in not answering or providing truncated answers to the various questions that Cambodia legitimately raises, but is also persisting in reversing the court's reasoning, treating legal logic with contempt. We had gallons of champagne. We had all sorts of costumes. We had saxophones and bagpipes serving as border markers. But we did not get what we had called for, a precise answer to the way in which Thailand can objectively deny the connection between the essential grounds of the 62 judgment and its dispositive. To the contrary, we got a further demonstration that actually it was the secondary grounds that were essential. Professor Crawford returned to Prince Damrong, the Washington Commission and all that, the 1949-1954 correspondence. Now, all of this, for the court, constitutes a reasoning which supports its main and essential observation, that the Annex 1 map as a frontier, as evidence of a frontier accepted by both parties and recognized by the court. And Professor Crawford does us a service when he cites an extract from the judgment and says, I quote, "What seems clear is that either Siam did not in fact believe she had any title, and this would be wholly consistent with her attitude all along, and thereafter to the Annex 1 map and line, or else she decided not to assert it," which again means that she accepted the French claim or accepted the frontier at Preavier as drawn on the map. End of quote. So quite clearly the court ties both solutions to acceptance of the Annex 1 map, which indicates the frontier. And consequently it becomes extremely difficult to assert on the one hand that this map plays an insignificant role in the reasoning of the court, and on the other hand that it does not represent a frontier, which therefore was delimited. And in Professor Crawford's style, Annex 1 map is a sort of is part of the decoration. It's a sort of a feather twisting and turning in the air, spiraling downwards at the whim of the wind, landing here, there or elsewhere on one of Madame Miron's very attractive, very pretty multicolored lines. But Madame Miron, some feathers have weighty consequences, but in her temple-centered approach she indicates to us once again that the sole purpose of the map was to prove that the temple was on the right side of the frontier, but she completely indicates that the court considered that this map had treaty status, and that it prevailed even over treaties. The very maps presented here, most of them not relevant to this case, should not mask the legal reality. It is a fact, as she says, that maps were given to the court, but it would be a good thing to point out that the court decided to use only one of them. However, we can agree with Professor Crawford that acquiescence must be precise, and acquiescence to the temple might not be synonymous with acquiescence to the map, but it's the other way round. We have acquiescence to the map, the consequence of which is acquiescence to the temple. Once again, it is this inductive reasoning at work.
Now, with respect to the continuation of the attempt to recast the judgment of 1962, Thailand seems to reproach Cambodia of wanting to take the 1962 judgment as a point of departure, not taking into account anything that happened before, and only to consider subsequent facts as evidence that there is indeed a dispute on the interpretation of the 1962 judgment. Nonetheless, Thailand threatens Cambodia with a slew of accusations running from misuse of procedure, concealed appeal, revisionist attempts, even an abuse of rights, because we're only talking about a few meters to be attributed. In other words, everything apart from the interpretation. Yet, Cambodia is only exercising a possibility offered to it under the statute of the court, namely, to request an interpretation on the meaning and scope of the judgment when it appears there is disagreement regarding the dispositive between two parties. Now, this possibility is indeed framed both by procedure and case law. Not only it should relate to what has been decided upon with binding force, the dispositif, together with the essential grounds if necessary, and it is in this particular case, but it may only interpret the judgment as handed down, and obviously cannot take account of subsequent practice unless precisely to determine the existence of a dispute on interpretation. So, where in this particular case is the procedural abuse? The instant case opposing Cambodia to Thailand corresponds wholly to these requirements. Once again, the usine, the Chorzul factory case perfectly sums it up. Let me quote: the interpretation adds nothing to the decision which has acquired the force of res judicata and can only have binding force within the limits of what was decided in the judgment construed. The court confines itself to explaining by an interpretation that upon which it's already passed judgment. That's the reason for which Cambodia confirms it is necessary to concentrate solely but entirely on the 1962 judgment, and it is vain and counterproductive to revisit what happened prior to that, since the court can't interpret the judgment, can only interpret the judgment as was handed down. Thus, to answer Professor McRae, why the judgment of 15 June 62 and only that judgment? Well, because it's an obligation under the statute of the court, by its procedure and by its case law. Now, beyond that, it's rather symptomatic to point out that Thailand reproaches Cambodia for seeking a revision of the judgment. Surely this is a tit-for-tat approach, because it's a temptation which clearly appears in Thailand's own approach, via this avalanche of maps, this never-ending revisiting of the watershed line. And yet the court clearly established that it mattered but little, since the parties had accepted the Annex 1 map line as a boundary line between the two states, and that this map corresponds yea or nay to the watershed line is a subject which was debated at length in the original proceedings which the court ruled upon, and on which it's vain to revisit unless one wishes to make the court lose its time. This silent raft of absent responses finally leads back to what our departure point was, namely the link between the core grounds and the dispositif, because Thailand has never demonstrated how or why you should read the dispositif independently of the reasoning. Now, to not annoy Professor Pele further, I'm not going to repeat what was characterized as common sense, of self-evidence, doctrinal nonsense. Well, it's not very charitable for doctrine, is it? But anyhow, that is a subsidiary means of the determination of the rules of law, according to Article 38 of your statute. It remains that it would have been desirable that Thailand should explain to us, and not only in this case, but generally, why Thailand absolutely refutes this linkage between the core reasoning and the dispositif, a linkage which has been accepted within the framework of interpretation by all international courts. That was also disregarded by Thailand. The denial, however brilliant that denial may be, can't replace explanation, but you must think at the end of the day that Thailand doesn't really like to explain the law. Now, we can agree that, I quote, interpretation must shed light on that which is obscure and not obscure that which is clear. I think that's the essence of all good teaching, but in this particular case obscurity persists, and it is for this reason that Cambodia has come back to your court. The question posed yesterday, to which my colleague Rudman Bundy responded, is the proof thereof. What is the vicinity or precincts situated on Cambodian territory for the two parties? It's clear that it's not clear, or rather it's clear that the two states do not have the same comprehension of what the vicinity of the temple situated on Cambodian territory is. The interpretation is necessary thus because Cambodia also would like to know what the precincts or vicinity situated on Cambodian territory are for Thailand. How many meters from the temple, and on what basis this vicinity has been established, because that is the question too. Now, Cambodia can say that its interpretation flows from its understanding of the judgment, and that for us the precincts or vicinity situated on Cambodian territory can only correspond to the finding made by the court with respect to the boundary indicated on the Annex 1 map, accepted by both parties, recognised by the court in its reasoning. But what is the basis on which the delimitation of the vicinity rests according to Thailand? This basis seems to come from some hypothetical watershed line that the court refused Thailand back in 1962. It's at least what you should understand via the explanation, rather confused and muddled explanation, concealed under an unbelievable arsenal of maps. Well, it's either that or a wholly arbitrary line. So there are only two possible hypotheses to calculate this limit for Thailand. Either the line which was refused back in 1962 or the invention of a wholly arbitrary line. Both of these are unacceptable. However, on the other hand, as confirmed by Cambodia, there is one objective element, indeed the only objective element, which enables us to ascertain the limit between the two states, and that's the line on the Annex 1 map. According to Professor Crawford, Cambodia has difficulties setting out a coherent and logical reading of the judgment. I quote him, because Cambodia asked for a determination today that the Annex 1 map line is to be considered as falling within the operative part of the judgment. Well, it seems that Thailand continues to have difficulties in understanding Cambodia's position. They continue to try to make us say what we haven't seen, namely that we're asking that the Annex 1 map line should be included in the dispositif. There is, in Thailand's part, this inexhaustible desire to travesty our request. We can't ask what cannot be, and the line on the Annex 1 map cannot be in the dispositif because it wasn't in the dispositif in 1962. So, we're not talking about interpreting a ground in the light of the dispositif, to rehearse the skillful formula of Professor Pelly. It's the other way round. But we don't want to revisit that whole demonstration. But, to come back to the essence of the question in hand, it is possible to cite a passage of the judgment of 15 June 1962, which was also cited yesterday by Thailand, which is quite apposite today to be cited by Cambodia and in its totality, because nothing runs counter in this extract that it is the right interpretation of the judgment. And I think it resumes most of the pending questions. I quote, "Accordingly, the subject of the dispute submitted to the court is confined to a difference of view about sovereignty over the region of the Temple of Priavia. To decide this question of territorial sovereignty, the court must have regard to the frontier line between the two states in this sector. Maps have been submitted to it and various considerations have been advanced in this connection. The court will have regard to each of these only to such extent as it may find in them reasons for the decision it has to give in order to settle the sole dispute submitted to it, the subject of which has just been stated." End of citation. So the subject of the dispute is a difference of view about sovereignty over the region of the Temple of Priavia, and not the temple by itself. Now, in order to decide on this territorial question, the court will have to have regard to the frontier line between the two states in this sector. In other words, to note what the boundary is between the two states. The distinction between territorial conflict and boundary conflict, the conflict thus disappears. Maps and considerations have been submitted to it, and we know that the court will only retain one relevant map, and the other considerations will come to support that evidence. The court acquiesces to this assertion, because that means that the court will build its judgment on these grounds and will retain the key one. This to decide on the dispute submitted, otherwise said as the beginning of this citation, and that is the difference of view about sovereignty over the region of the Temple of Priavia. And the court will only relate to the motives here. Now, this also relates to the opinion of Judges Tanaka and Morelli in their joint declaration, because they said, I quote them, "The claim as it is formulated in Cambodia's application is directed not to the return of the temple as such, but rather to sovereignty over the portion of territory in which the temple is situated." Now, Cambodia has nothing to say whatsoever about this common sense finding. That's what the court will do, and that's what Cambodia accepts perfectly, because that certainly doesn't mean that the court is in any way disregarding the essential ground on which the court will base itself and which will condition the dispositif to come. Without this ground, without this reasoning, the judgment of which as it is today would not exist. All this confirms the consistent reading of the judgment of 1962 by Cambodia. Just as a conclusion, Cambodia would like to come back to what had been introduced in its pleadings, namely, it is necessary to sum up once again simply the way in which Cambodia is dealing with this case before you. It's all about interpreting paragraph 2 of the dispositif of the judgment of 15 June 1962 in the light of paragraph 1. And this in direct liaison with the obligation for Thailand to withdraw its troops stationed at the temple or in its vicinity on Cambodian territory. As such, the reference to Cambodian territory can only be understood with regard to what the court said regarding the acceptance by both parties of the Annex 1 map as indicating the frontier line in the region of the temple. This fundamental ground indicated by the court is thus inseparable from the dispositif. And from this it flows that the obligation of evacuating the troops is an ongoing obligation which must be understood in relationship to the Annex 1 line, and that the unilateral and voluntary restrictive interpretation of the judgment by Thailand is unacceptable. Mr. President, distinguished members of the court, I thank you for your kind attention, and I request now, Mr. President, if you will be so kind as to give the floor to the Deputy Prime Minister, the agent of the Kingdom of Cambodia.
Monsieur le
Professor.
Je passe la parole à son...
Thank you, and I now give the floor to the agent, Deputy Prime Minister, and agent of the Kingdom of Cambodia. You have the floor, sir. Mr. President, distinguished members of the court, it is for me an honour to be able to come before you once again, before your honourable and prestigious court, to bring to a close the pleadings of the Kingdom of Cambodia. But before reading the submissions, I should wish, on behalf of my delegation, to thank the court for the care and attention that the court has shown for this case. The Kingdom of Cambodia is particularly grateful to the court for having given to the parties in the instant case the opportunity to fully express themselves by authorizing the production both of written observations and organizing a whole week of hearings. Our thanks also go to the registrar and to his team, whose efficiency and professionalism have been greatly appreciated. I make the most of this occasion to single out in particular the work of the interpreters, who accomplished a difficult task with great success. Mr. President, distinguished members of the court, as I indicated during the opening of the pleadings on 15 April, it falls to me to insist on the importance which Cambodia accords to the decision of this court, which will certainly condition the relations between these two states, a decision on which peace and security in the region depend. Because Cambodia is persuaded that the court has a fundamental role to play in ensuring peace between peoples. Without a definitive interpretation of the judgment of 15 June 1962, the status quo situation which would result would certainly have unfortunate consequences which would stand in the way both of the necessity to live in a friendly, peaceful and cooperative environment between the two states, and also that the court must be fully aware of the way in which Thailand imperfectly applies those provisional measures handed down by your court in your order of 18 July 2011. As I've already recalled in my intervention on Monday, Thailand's unfounded claims for these 4.6 square kilometres confirmed in an official publication of the Thai Foreign Ministry in 2011, the military occupations of certain portions of our territories in the vicinity of the temple, and a series of armed attacks which have led to deaths, casualties and displaced populations, have been a considerable problem. This is no longer acceptable. So there are new and recent facts which justify our request for interpretation. We are of the opinion that your court will be fully aware of this when you take your decision. The result is that Cambodia waits with serenity your decision to bring to a definitive closure this dispute relating precisely to the meaning and scope of the 1962 judgment, which prevents the development of peaceful relations between two neighbours which everything should normally bring closer. As Mr. Bundy could explain to your court in response to the question posed by Judge Yusuf, Cambodia has always, since your judgment of 15 June 1962, interpreted the vicinity of the temple with respect to the line drawn on the Annex 1 map. Mr. President, distinguished members of the court, Cambodia now comes to the submissions that it wishes to present to your court. In order so to do, we shall recall first of all the different submissions set out in our written and oral pleadings. The submissions submitted to the court by each of the two parties show, both in themselves and in the light of the facts, that the parties are in disagreement on the meaning and scope of the judgment of 1962. That the disputes between the parties relate both to the interpretation of the first paragraph and to the interpretation of the second paragraph of the dispositif, the 1962 judgment, and also on the inseparable link between these two paragraphs. That each of these aforementioned disputes relate to what the court decided with binding force, including a dispute as to whether this or that point has been decided by binding force, and that the findings of the court in the judgment of 15 June 1962 regarding the binding character of the line on the Annex 1 map are inseparable from the dispositif and indispensable for the interpretation of the judgment. That on the basis of what the court has decided with respect to the legal status of the Annex 1 map as representing the boundary between the two states, the expressions in territory under the sovereignty of Cambodia, that's paragraph 1 of the dispositif, and on Cambodian territory, that's paragraph 2 of the dispositif, have to be understood in the light of this boundary in the region of the Temple of Preah Vihear, and that the obligation of withdrawal set out in paragraph 2 of the dispositif has to be understood as a continuous ongoing obligation which extends to the totality of the territory under the sovereignty of Cambodia as defined in the disputed area. So dismissing the submissions of the Kingdom of Thailand on the base of the foregoing points, Cambodia respectfully requests the court in application of Article 60 of its statute to respond to Cambodia's request for the interpretation of the court's judgment of 15 June 1962. According to Cambodia, the Temple of Preah Vihear is situated in territory under the sovereignty of Cambodia. That's paragraph 1 of the dispositif, which is the legal consequence of the fact that the temple is situated on the Cambodian side of the frontier as recognized by the court in its judgment, and that thus the obligation for Thailand to withdraw any military or police forces or other guards or keepers stationed by her at the temple or in its vicinity on Cambodian territory, that's paragraph 2 of the dispositif, is a specific consequence of the general and continuous obligation to respect the territorial integrity of Cambodia, territory delimited in the area of the temple and its vicinity by the line of the Annex 1 map on which the court's judgment is based. I'd like to thank you, Mr. President, distinguished members of the court, for your kind attention.
Je vous remercie.
Thank you. Your Excellency, the court has noted the final submissions that you have just read on behalf of the Kingdom of Cambodia. The Kingdom of Thailand will proceed with its second round of pleadings on Friday, 19th April, from 3 p.m. till 5 p.m. Meeting stands adjourned.